I'm Daniel Tibbett on behalf of Elijah Ellington. I'd ask to reserve 2 minutes for rebuttal.
Okay, once it gets down to 2, the yellow light will go on as kind of a reminder to you that you have 2 left.
Okay, very good. In this case, Elijah Ellington was denied his right to exercise a peremptory challenge on a juror that he did not want in his jury. This resulted in that juror sitting on the jury that convicted him of a charge that carried a 20-year min-man, even for a first offender like himself, which is the sentence that he's now serving. The Florida Supreme Court in Hayes said that peremptory challenges are one of the most important rights secured to the accused, and it's a right that's limited only by the rule that the challenge on the juror cannot be used on the basis of discrimination, cannot be discriminatory based on race, ethnicity, or gender.
Let me ask you this question, if I may. I remember reading, I guess 9-10 years ago, it was in the Florida Bar News. It may have been in the actual magazine that comes out, and I remember the cover story was, "Is the peremptory challenge dead?" Because of this, because of all this. So that is a lead into my question as follows: didn't the trial judge get over the finish line to the extent that this trial judge has to be affirmed on this issue, because the trial judge said, based on everything I have heard, I'm going to deny your peremptory? Isn't that really enough from these 3 guys sitting up here on Palm Beach Lakes Boulevard? Isn't that really enough for purposes of our analysis of the record?
It's not, Your Honor, and the reason, or the authority that I would cite to support the statement that it's not is the Florida Supreme Court in Hayes, this court in Siegel, this court in, I believe it's Jones was the other fourth DCA case that I think was right on point. All those cases, it is Jones, all those cases say that if yes, there's deference, which is what Your Honor is referring to. You're not sitting there listening to the jury. But there's also this important right at stake of the defense's right and the state's right, every litigant's right to use peremptory challenges on jurors they don't want. So if there's no record, and if the trial court doesn't do what's required in the third step of Melbourne, which is to articulate reasons why it believes that the defense has not put forth a genuinely, in this case, gender-neutral reason, which, the bottom line is the lower court is saying, I'm finding you're discriminating based on gender. The reason you really want to strike this juror is because she's a woman, and you can't do that, so we're not allowing you to do that. When this court looks at it, this court has to look at the record and the findings that the court made, and all those cases that I mentioned say that you basically can't have deference to a cold record, and the fact that it's an abuse.
And in this case, though, I think what Judge Sicklin is concerned about, and I'm concerned about, is the judge specifically asked for clarification. You're telling me that you're wanting to strike this juror because she has a identity theft. She's a victim of identity theft. There were several other people on the panel already that had been victims of theft, but for some reason identity theft was making a difference, and she wanted clarification, and that was confirmed. Okay? I'm going to ask what I assume Judge Scherer was a little concerned about. Why are you focusing on identity theft in this case? There's other thefts out there that people have been victims of, but for some reason you're telling me you want to excuse this lady because of an identity theft. What's the connection between identity theft, being a victim of that, and this the crime that's going to be tried in this case?
Right. Now, I understand what Your Honor's saying, and I can't get in the shoes of the trial attorney and tell you,
but don't you agree
why that would be? But what I can say,
and the state also made that point that it seems a little ridiculous that you're focusing on identity theft, and it just seems kind of obvious, and if the defense doesn't explain something about that, not necessarily having to tip your hand about your whole defense or anything, but just give some explanation, isn't it fair for the trial judge to think, well, this sounds a little pretextual then?
No, I think no, and the reason I think no is because that is, whether you agree with the reason, that I don't want the jury because it's identity theft, if you were sitting as an attorney or if I was, whether you would, strike a juror for that reason, that's not the question with a peremptory challenge. This is not a cause challenge where we're saying, the juror can't be fair, which obviously this reason would not rise to that level. But for a peremptory challenge, all you got to do, you can use any reason, except that it can't be discriminatory. So,
But even if it was something like, I don't want this juror because they have brown hair. Mm-hmm. And if the judge asked a question, you don't want a juror because of brown hair, it seems to me most attorneys will say, well, Judge, my experience has been, I've done XYZ number of trials, and it seems like every time I have a brown-haired juror on there, something, I get a negative, there's some explanation about why I'm targeting that issue. So there's nothing in this record to, and I understand that you don't have to have everyone doesn't have to agree with your logic about why you want to excuse someone, but doesn't there have to be some kind of logic to it to satisfy the trial judge that this is not a pretext?
I think that, frankly, the answer to that is no, as long as it's not, and there's plenty of
Well, if that's the
reasons
case, then no one's ever going to be able to win on this kind of a challenge, because you can always come up with a reason, doesn't have to make any sense, but, I just, I didn't like the way she walked in the court. If you don't have to supply some kind of logic, then there's no way that you're ever going to be able to overcome that kind of discriminatory challenge.
Well, let me pivot to another reason that the attorney gave that there was logic articulated behind, whether or not the court agrees with it, which is the reason that this juror was from Michigan. So even if that's the court's position, is that you have to articulate some logic as the defendant or the proponent of the strike.
But in saying from Michigan, also mentioned, which is a anti-gun state.
Right.
So again, you can understand kind of the logic of it. But
So
just
that's
saying,
a gender-neutral reason that there was some logic articulated behind it. So that alone, forget about the identity theft, is enough to get over the hurdle of showing a non-pretextual reason, which is a low bar, because all these cases say, and the Florida Supreme Court has strongly said in Hayes, that this right to get jurors off the jury that you don't want as a defendant for whatever reason, as long as it's not discrimination, it must be protected by the courts. So when he says, look, I don't want a juror from Michigan, I perceive Michigan as being an anti-gun state, and I actually cited some evidence of that in the reply brief, that there are some stricter handgun laws in Michigan than we have in Florida. So there's some actual basis for that. Let's remember, the cases all say that the burden here is on the state, in this case, the state, the opponent of the strike, to demonstrate that it's pretextual. So it's an error alone to put the burden on the defendant. But, here the state objected, the defendant said, let's just focus on Michigan, because I think, look, the jurors from Michigan, I think they're anti-gun. This is a gun case. My guy's walking around with a handgun. That's the underlying facts of the case. He's walking around with a handgun, which he doesn't have, a license for. You don't have to in Florida. And I'm concerned about the gun laws of Michigan and this juror being from Michigan. So the state responds to that by saying, well, I think there was other jurors from Michigan, which is not true, not borne out by the record. Later, another juror from Michigan came up, but the defense struck them too. So, and the state says something about jurors from Boston, which is irrelevant. So there we have an articulated reason, gender neutral, and that means that it's error under these cases. I'd point the court, and I'll sit down and reserve at least a minute, but I'd point the court to its own decision in Siegel, where it said that the court has to look at the factors, number one, racial, gender makeup of the veneer as it exists so far. Number two, prior strikes against the same group. Did he strike other women? Number three, are there other jurors that have the same reason applicable to them that weren't struck? Number four, did he single out that juror for special treatment? And if the court doesn't go through that analysis, the Siegel court said, then this court is basically constrained, if there was a gender-neutral reason articulated, to reverse. So we think that that's the only proper result here, and I'd reserve the remainder of my time.
Sir.
Alan Giese on behalf of the state of Florida. The first thing I would like to point out is what this court said in Siegel. There is nothing in Melbourne which requires trial judges to articulate their thought process on the issue of pretext. That's what this court has said in Siegel. That's what the Florida Supreme Court has said in Hayes. They don't have to articulate it. And the cases that have been reversed are cases where the record, where there was completely devoid of any type of genuineness in valuation. Here, I quoted the entire conversation on this particular issue, on this particular juror, and I think it was 4 pages in my brief, and it's all about genuineness. This is not a case where the record's completely devoid of a genuineness evaluation.
Well, let me ask this, because Mr. Tibbetts' response a few moments ago actually raised something in my mind I had not thought about before. And what about the situation where, the opponent to the strike gives, in this case, 3 reasons, and 2 of them may seemingly have some validity to it in the sense that there's some logic to it. The other one's just totally illogical. So what happens if it's a situation where one of them clearly looks bogus, but the other 2 might have some substance to it?
Well, I think the fact that one is totally bogus raises the question of whether or not the lawyer is being honest and straightforward, or if he has some ulterior motive, like trying to knock women off this jury because it's a robbery case and he doesn't believe women will be as receptive as men will to a self-defense theory. In this case, I submit that the first reason he gave, that it's identity theft, is absolutely ridiculous. Second one, since I'm from Michigan, I'm very offended, and I find it just as ludicrous that somebody from Michigan can't be fair and impartial in a armed robbery case or aggravated battery case. The third issue that they raised has no support in the record. So I submit all 3 of the reasons given are bogus. And you got to remember, the trial court's looking at this in light of the entire voir dire. And when there was a challenge for cause by the state, it was a very obvious challenge for cause where the juror said that their father's in prison for federal arms dealing charges, and they have a question if they could be fair or not. This same lawyer said, "Oh no, I think he'd be a really good lawyer." So, the courts just heard him go through this and made some comment saying, "What is this, a joke?" Or, if it'd be a joke if you weren't saying it out loud, something to that comment. So this court already had an issue where he felt that the counsel was being disingenuous. Then he gets up and argues that he wants this woman, and he's excused 1 man and 2 women so far. Ultimately, he ends up excusing 2 men and 4 women total.
What about the excuse, my client doesn't like this juror? What about that excuse?
I think the trial court was exactly right. That's not a race-neutral reason. You are right as a trial lawyer
The person
to
who's
excuse
facing
somebody is limited because he can't discriminate. And if his client wants to discriminate against this woman, he cannot do that.
Well, you're assuming they're discriminating because she's a woman, but you don't really know that, do you?
That's what was raised in this issue. The prosecutor said, "Judge, he's already excused 2 women. We would ask for a gender-neutral reason." And that's why the court asked then properly under the everything that's set out in Hayes in Melbourne, properly asked for a race or gender neutral reason in this case. And then when the lawyer gives what are clearly bogus reasons for excusing this female juror, that's what keyed the judge in and the prosecutor in and said, "Wait a minute, you're exercising this in a discriminatory manner," and the judge disallowed the peremptory. That's exactly what happened. And there's evidence in the record to support it, and I've set it out in my brief, This is not a case where it's completely devoid of a genuineness evaluation. The trial court, what burden are you putting on the trial court? This judge obviously understood what was required. She obviously understood that the genuineness of the state's objection is not the issue here. The good faith of the state's objection. She's very specifically narrowed in on what's required under Hayes and Melbourne, and did a proper evaluation, and then based upon the totality of the answers and based upon the totality of what had taken place before at this point, ruled that it was a discriminatory exercise of a peremptory and disallowed it. I don't know about the other two issues. I think those are fairly clear. The ag battery obviously occurred. There's an in and out through the shirt, something very close and personal to the victim in the case. He showed his scar to the jury. And the third issue, obviously, I think is well briefed, and I don't think there's an issue unless the court has a question there either. But the court did a proper genuineness evaluation, and I just ask the court to affirm, unless there's other questions.
Thank you.
Thank you.
Right after the part of Siegel that Mr. Giese read, that there's nothing in Melbourne that requires trial judges to articulate their thought process on the issue of pretext, the court goes on. But where a gender or race neutral reason was advanced for the strike, the reason advanced is itself reasonable, Michigan, and the record is devoid of any indication that the trial judge considered the relevant circumstances surrounding the strike and concluding that it was motivated by improper purposes, an appellate court must conclude that the trial judge failed to adequately engage in the genuine inquiry mandated by Melbourne. I think we're reading a different record when we're talking about, when we're arguing that the judge thoroughly went into the genuineness. If you look at what the court actually said, it's a few lines and the court contradicts itself. I think the totality of the reasons given are neutral. Whether or not those are genuine, I don't know. Not to say you're disingenuous, Mr. Heiss, but I suspect your client doesn't want her and there's no neutral reason, therefore we're giving any reason and they don't seem to be genuine. So the court first says they're neutral, then says there's no neutral reason. The court first says I don't know if they're genuine, and then makes the ultimate finding that there's not. There's no inquiry as to the, Michigan issue or further inquiry into whether that's pretextual. That's a gender neutral reason. Under the case law, he has a right to strike, the defendant has a right to strike this juror. The court's finding that it was discriminatory is incorrect on this record. To answer your Honor's question, Judge Connor, about what if there's a few reasons and we disagree with, one of them, if you look at the Hayes case featured a few reasons. It was, she has some relatives in law enforcement, and then, she didn't really answer questions, she didn't say much, she's an unknown quantity. So, the court only focused, you just need one, is the answer. If there's a gender neutral reason, that's all you need. Here, there's no analysis by the court as to the genuineness. That's what the case law requires. Otherwise, you're just rubber stamping the trial court, which is exactly what all these cases say that the appellate courts should not do. So we'd ask that the court reverse and remand for a new trial where the defendant has the right to exercise peremptory challenges. Thank you.
All right, thank you, gentlemen. Okay, our next one up